Hi, I'm Dan Collins, a Sacramento, California real estate broker and licensed general contractor who specializes in selling properties in probate. I recently published a book entitled Probate and Trust Estate Administration Tips and Tricks, which is available on Amazon. I have developed effective systems to position and sell probate properties that can sometimes save 4 or more months of time to complete a probate involving real property. To learn more, please visit my website, collinsfiduciarybroker.com. Today I want to talk about breaking impasses in trust beneficiary litigation over estate house disputes. Yesterday I spent the day in a settlement conference at a Bay Area Superior Court. I was hired by a law firm to act as a guardian ad litem for a beneficiary who lacked capacity to represent their own interest over a family estate dispute in their family trust. In California, litigation over transfer of the family home in a probate or trust estate is one of the most common fights between estate beneficiaries. Often, these situations arise when one sibling becomes a caretaker for mom or dad before they die. Sometimes the sibling will live with the parent for years prior to their death, and they become interdependent upon each other. The parent requires someone to look after them, and the child who cares for them becomes dependent upon the parent for their source of housing and their income. When the parent dies, this sometimes leaves the child vulnerable to major life change when the child and the other beneficiaries settle the estate of the deceased. I have seen different ways that siblings who are parents' caretaker before death seek to protect their own interests at the expense of their siblings when they realize the parent whom they have become dependent upon is going to die. Most frequently, I see evidence of the caretaker using their influence to get mom or dad to make changes to their wills, leaving the family home to that child who lived with them at the end, at the exclusion of their siblings. When the family home is the most valuable estate asset, this devised gifting of the family home to one child often causes disputes with other siblings. During the dispute, as the layers of the onion are peeled back, it sometimes exposes facts supporting elder abuse via undue influence. So how does this problem arise? Common forms of undue influence with aging parents include changing wills to devise the property to one beneficiary over the exclusion of other beneficiaries. Another common influence technique is hiring unscrupulous lawyers to create revocable trusts within months or weeks of death when the elder lacks capacity, ends up favoring one sibling over the other siblings. I've seen this situation many times in my consulting work for attorneys in matters of trust and probate litigation. In the settlement conference I attended yesterday, the beneficiary, who influenced the last surviving parent to leave the family home to them and exclude the other brothers and sisters, the decedent did not understand the English language. In fact, the elder could not read English, nor could they read in their own native tongue. Yet an unscrupulous attorney prepared a revocable living trust for this elderly person less than 2 weeks before they died. There were other telltale signs of influence that meet the legal definition of elder abuse in this case also. The defendant beneficiary finally realized during our long settlement conference that they likely would not win at trial. In fact, failure on the perpetrator's part to settle could have resulted in that beneficiary losing the house and having to pay for their siblings' legal fees. So we were able to settle the dispute and avoid a jury trial. There are many ways to settle a house fight in litigation. Parties can agree to equal percentage splits of sale proceeds. Parties can also agree that one or more parties receive a sum certain at the time of sale, and other parties will divide the remainder. If one or more of the parties will receive some certain amounts, will there be trust deeds recorded against the property? It might be advisable to do so. Or, parties can agree that variable percentages be distributed based upon certain beneficiaries having greater interest in personal or over real property. What is easy to forget when you are sitting in a conference room full of attorneys and a mediator is there are many details to attend to in preparing an estate home for sale. Often, these details are overlooked when the attorneys draft settlement agreements, and it can cause problems that can threaten the settlement when beneficiaries are attending to selling the home. Examples of issues I regularly see include the child who lived with mom or dad for years before they died doesn't have a job or a place to live, and they lack the necessary finances to secure a new home and move out of the one that needs to be sold. Sometimes placing a small, short-term loan against the estate home will help that sibling receive some money and find a place to live so the family home can be sold. The loaned amount of money will be credited towards the child's share of the estate and can be repaid at the time of sale. Other issues include personal property being abandoned in the house. All the estate beneficiaries have taken what they want, and now there are literally several tons of personal property that no one wants. The garbage needs to be removed and taken to a dump. Should settlement agreements include who is responsible to leave the home in broom-clean condition? I think so. It would avoid a lot of post-settlement fights. If the settlement agreements are crafted with the steps necessary to prepare an estate home for sale, it will result in fewer post-settlement issues. If you are buying or selling a piece of probate or conservatorship real estate and you don't care about saving time or money, any licensed real estate broker will do. But if time and money are important to you, then hire the best. Hire Collins Fiduciary Broker to represent you in your fiduciary property transaction. We know probate. If you want to know more ways to avoid estate administration pitfalls, please read my new book, Probate Trust Estate Administration Tips and Tricks, which is available on Amazon. If you would like a free PDF copy, please just text me or call me at area code 916-215-2042. For more videos and information, feel free to visit my website, collinsfiduciarybroker.com. I'm Dan Collins. Thank you for watching.